Yes. Good morning, class. Today we're going to learn about money. And what is money, Kinodhia? Kinodhia, umerara darasani. I told you you'd be just like your father. Alikuwa anaitwa nani?
Douglas.
Douglas mwalimu. Hata ndio Kegere. Mnaweza toka mfanye shughuli zenu tubaki na Kinodhia. Lakini hii kazi ya kuwa mwalimu ni gumu sana. Lakini allow me to introduce myself. So welcome back, guys, and today we're going to go through the fire drill and we want to find out where does our money go to. According to the Kenya National Bureau of Statistics, Kenyans take their money into these 5 places. And where do you as an individual take your money? Meals and bills, hapo uko na ngapi? Malls and bars, hapo uko na ngapi? Homes and cars, plots and shares, debt and bed. Unajua msijifiche. Yes, and now that you know where you take your money, what are your red flags? What are those things that you need to change? So I'm going to take an example with myself as a teacher. Meals and bills. Hapo kwa meals unajua as a teacher nakula pale kwa dining halls na bills. Unajua ukioga tu na maji baridi hata sina tokens. Hapo kuna 10%. Malls and bars. Malls. Unajua kazi ya kuwa mwalimu ni ngumu, niko tu huku ndani kwa staff room kila saa. Bars niliokoka 10%. Homes and cars, kuna ile nyumba najenga na bibi yangu. Na gari unajua niko na privilege ya school bus 30%. Plots and shares, kuna shamba nanunua pale Kamunyu. Hapo ndio najua, hapo ndio kwa plots and shares zanipea 50%. Na debt and bet mimi huko nilitoka a good 0%. Looking at my breakdown, 50% in plots and shares is a bit too much. That plot is just sitting somewhere and it does not give me any passive income. So as a mechanism, I think it would be best if I nitafute wale watu wasavu nasikia wanaitwa sijui fire partners. Wanauza manyumba na hiyo nyumba inanipea good monthly income. So if 50% kutoka kwa mali moja, hiyo haitaweza. So what I want to do moving forward is taking that money that is at 50% in one investment that does not give me any passive income to a servo house that is going to give me passive monthly income. So thanks guys. Kinodhia bado narara na nani hiyo kado yako? Can the both of you 3 come here?
Owning your first apartment in Nairobi has never been easier. It's simple. With 0 deposit and 0% interest rate, you can pay as little as 30,000 per month for up to 5 years. Just divide the price by the number of months you want to pay. Visit www.savo.ke to learn more.
Good evening everyone. Happy to be here. On my left, I'm joined by, I think, lawyers we've worked with since we began Savo. They've been with us throughout our journey. They've helped us with, a lot of lawyer issues and structuring of the company, and they've been part of the growth that we've been undergoing here in Savo. So I think I would like them to introduce themselves. Yeah. Yes, and then we'll come back. Okay.
Sure. Thank you, Karen, for having us here again. We're very happy to be here, as usual.
Yeah.
My name is Fidel Mwaki, founder at FMC Advocates. Our law firm has been a partner of Savo for almost 7 years.
Yeah.
We have helped Savo in terms of just helping them, structure their projects and help with sales and, all legal aspects of all your transactions. So we're very happy to be here again.
Yeah.
Thank you.
Thank you.
Thank you, Karen and Savo, for hosting us once again. My name is Dana Wariara.
I work at FMC Advocates, and we also work very closely with Savo on their projects. Yeah.
Okay, this is awesome. If you've seen the titling of the heading for today's topic, then you know I'm seated with the right people at the table. So I think we'll go straight to a word of prayer before I even introduce the topic. Then would you like to pray for us?
Thank you. Let's bow our heads for a word of prayer. Dear Lord, we come before you this evening with thanksgiving in our hearts. We want to say thank you for the gift of life and for the gift of partnerships. As we start this webinar, we ask that you may be with us, that you may guide us, you may guide the conversation, that we may enlighten each other and educate each other. In Jesus' name we pray. Amen.
Great. Happy to see that most of you have tuned in for another educative session. Once you join us, please drop your fire emoji. Agnes Wanjiru, very great to see you here. Peter London, I can see your fire emojis. MSP, you're saying great passive income. I think you understand what we are all about. You're all about fire. Ryan, Tom, thank you all for being here. And for joining us. You can send in your comments and your questions, ask your wakili any questions that you would have or anything that you've engaged with that has confused you. So today's webinar is about decoding legal jargon. Things that when I'm engaging with a lawyer, they would say, and I'm like, okay, so now what's that, you know? And they would explain to you over and over again, and you still will forget the next time you're engaging with another sale agreement. So being a real estate investment company here at Savo, since we're selling apartments, and then we engage into a lot of sale agreement contracts with most of our investors, and this understanding and knowledge really is a point of contact for us with our investors. So we'd really like to break it down in simple terms for you to be able to understand. And we'll be hearing from the experts. So, Sindel. Before I get right into it, I think I'd ask you to just send any questions. You've interacted with more sale agreements, you've interacted with other contracts that you'd want to know what did those words mean. Yeah. I think we'll get straight into it and go to the first section of our discussion today. And I think this is about offer letters and sale agreements. And I'd have like a few questions to ask you. Is an offer letter a binding agreement? Are there a final document to a transaction? Why would I sign an offer letter now and then after a few months come and sign a sale agreement? You know, because that's like the beginning. Anytime you're selling a project, the very first thing before you send money into that project or you get into an engagement with that customer, the very first thing you're discussing is what are the terms of this, you know, sale agreement. So what's that? The document in its summary.
Okay, thanks.
Yeah.
Thank you, Karen. That's actually a very interesting question. And it's a question that we get a lot as transaction advocates, whether, you know, whether the offer letter is a binding agreement, if it's a final agreement, and why do I have to sign so many documents? Mm-hmm. So maybe I can just shed light on what an offer letter is and why we sign an offer letter. Then Fidel will debunk the sale agreement. So when it comes to an offer letter, it's like the precursor. An offer letter is what is signed at the initial stages. So you'll find maybe you want to put down a deposit for this particular apartment, and maybe the sale agreement might not be ready. So the offer letter is what you use to book the apartment and pay that initial deposit. But it's like, it's only an expression of interest. It's not a legally binding document. And to some extent, some clauses in the offer letter might be binding, but you'll find the transaction is better explained in the sale agreement, and it's explained in more detail. So an offer letter just gives a brief overview of the entire transaction and what you can expect as an investor, but it's not the final document. And mostly it's used to make sure that I have a document between me and the developer, and to make sure that I secure this particular apartment as the sale agreement is prepared for me. And now when you get to that point, now you'll review the sale agreement in detail and then sign that. Yes, I think Fidel can give a bit more insight on the sale agreements.
Yeah, so I think Diana has really set out clearly what an offer letter is. So with the sale agreement, this is actually the binding agreement that parties would sign. It's actually a legally required document. So whenever you are entering into a transaction with Savo and you want to buy a unit, the sale agreement is actually the main document because it sets out all the terms of sale. Yeah, from the initial recitals which talk about what the project is about, to all the payment plans and all the obligations of the parties. Sets out also clearly how someone can leave the transaction as well, and has detailed provisions on what happens if, say, for example, Savo delays in constructing or the investor delays in paying. So the sale agreement is actually the most important document, and frequently whenever we're doing a transaction, you'll find that the document the other party wants to see, most important, is the sale agreement. So it's a critical document.
So really a protection of both parties and not just for Savo's interest.
Absolutely.
I think we've seen in certain cases where an investor would come, they put in money, but they've not even signed the sale agreement to protect it.
Exactly.
So I think from this we're getting that it's to your own benefit if you're able to do this. So for those investors who are just joining us or those who have been with us and have not taken this step yet, before I get into a contract with, so this sale agreement or offer letter with an organization, now like Savo, there are things that I need to do, there are promises that are being made within the agreement and there are things I can check for before. So that brings us to like the next step, which is due diligence and warranties. I think one of like my question would be, in terms of warranties, are these things, are they legally binding? Are warranties legally binding? They create a liability in the event that I don't meet my promises if I've given a warranty. And then where will I give this warranty from? Is it word of mouth? Should it be written on email? Like where am I finding all this? And then what are some of, in real estate now, like we are in Savo, what are some of the things that I can't prove factually from doing due diligence, then would be promises within the transaction or in the contract? So,
maybe I'll start on this round. I think whenever we're dealing with an investor, one of the key things that they always ask is, can we see your documentation? Because they want to do searches and stuff like that. Or they'll ask us queries, can you confirm ABC about, say, the project? Has the project developed, has the developer done so and so? So some of these issues can be dealt with through documentation, which is what we give them, and then they review. And I think that Diana can talk on that a bit more. But the other thing, the issues, the questions that they ask sometimes which cannot be answered by documentation, like the warranties, what we call warranties. Warranties essentially are like representations that we make. So you as a buyer, you come in, you want to look at a project, so you're relying on certain information that the developer is saying. So you as Karen, who's with the developer, will say, this is our property, we own it. So me as Fidel, I'll come in and say, okay, so that's I'm relying on that. That's a representation you're making. So that automatically that is a warranty that you're given. Another representation you could give is, here we've never had an issue with our neighbors. Our property is fine. We don't have any issues. There's no one encroaching. There's no one. The neighbors have no problem with us. Again, you're giving a representation to that person. So in our sale agreements, what we have there's a section on warranties. Now, warranties, usually what we put in our sale agreement, remember we talked about a sale agreement being binding. So it's important that certain warranties, if they're going to be binding on the developer, are put in the sale agreement. So one of the warranties we will usually put is the developer is the legal and beneficial owner of the property. That's a warranty that you're giving. So it's just representations that someone is relying upon to enter into the agreement. Yes. Some of these warranties are warranties given because the documentation cannot confirm. So things like, somebody wants to do a search. Yes, you go do a search, but you may not be able to find some information based on the search that satisfies that warranty. So Diana, maybe you can expound.
So due diligence essentially is, this is basically fact checking. So you'll find you do your due diligence to confirm certain facts that have been presented to you by the developer. So for instance, if I tell you that I own this land and I give you a copy of the title, it's most prudent for you to go and verify these facts at the lands registry. You get a land search. If I tell you I'm a shareholder in this company, it's important that you take the extra steps to verify what I'm telling you by going to the company's registry and obtaining a company search and saying, oh, I can see Karen is a shareholder and she's a director, so she's authorized to sign, this documentation. So essentially, due diligence is what it basically confirms certain facts about the project, and it also speaks to the intention of now the developer to actually see this project through. Because you'll find if Savo has now, for instance, if they've said they want to construct a certain development, for instance, Savo Divine, they've taken the requisite steps. They've acquired the property, so they have a title in the name. They've gotten the building plans. They've gone ahead and they've done a change of user. If they've taken all those steps, it shows that they actually have the full intention of seeing this project through. So constructing and finalizing on the development, because actually acquiring this documentation is a lot of work. It's a lot of hard work. So you wouldn't go the extra mile of getting this documentation if you don't have the intention of seeing the project through.
Seeing the project through. And I think here at Savo we go an extra mile to creating like a due diligence package for our investors, where if someone requests you able to give it to them, but this also needs to be confirmed by you yourself who's getting into the contract. Because then again, you don't want to believe everyone's word. Maybe just in a nutshell, I know you've mentioned some of it in real estate. What are these things that need to be factually proven before you get into a contract with someone? Like now you're looking to engage with Savo in buying a property. What are these things that you need to factually prove before you get into contract?
I think first and foremost, you need to check the property where the development is going to be. You want to know who owns that particular property, and you want to confirm that there are no encumbrances or there are no third parties who have claims to that particular property. So this is information that you can ascertain by doing a land search at the lands registry. So like let's say in the case of Savo Sunset, if it's based here in Tindegwa, then you go to Kiambu Lands Registry and you do a search. So once you get the search, it will give you all details. It will show you that Savo Sunset is the owner of the property, and there are no encumbrances, there are no charges against the against the property. So it shows that he has a clean title to that property. So that will give you comfort. I think another thing that you'd want to see is Savo Sunset is a company, and you'd want to know who's behind this particular company, who are the directors in the company. Are there any encumbrances that are registered against the company? So you do this by just obtaining a company search, which you can do from the comfort of your home. You just log onto your laptop and you go on eCitizen and get the search. So once you log in and you see on the company that Savo owns the company and they have majority shareholding, and you'll find the directors. The directors in the developer, the developers are also the directors there, then it gives you comfort.
Fidel, there's a word Dana keeps using, encumbrance. Something.
Well, I know she'll answer it, but then I'll answer it for you. So an encumbrance is like something that has been registered against the title that may be affecting, certain rights of say, the owner. So the owner may have taken a loan with the bank. So the bank has put a charge, what's called a charge or a security interest against that title, which encumbers it. So the owner cannot just freely deal with it. So, and I feel this due diligence, if you just look at the word diligence, it should now put it in the investor's mind to be diligent
about it.
Don't just get the sale agreement and not start asking questions. And the good thing with Savo and our transactions is we're very open. If you have questions, be satisfied. Ask as many questions as you need to have answers for, and that is part of your diligence.
Okay, that's very interesting. Okay, I think now we can move to the other part of change of user and change of title. I think there's usually a lot of confusion of what's the difference between these two. Are they the same thing? What are you trying to achieve when you do a change of user? What are you trying to achieve when you do a change of title? And what do these processes look like? And why is it important for me to know about all this when I'm investing in real estate?
Right.
So, yeah.
Should I take this one or? Okay. So they're both connected. Change of user and change of title are connected.
Yeah.
Generally what happens when a lot of, when Savo, is acquiring property that they want to use for development, you'll find that they will be acquiring a property where the user may have been just residential use. Yeah. Which is okay because that's what that's what happens. Yeah? So that use has to be changed to multi-residential to allow this wonderful building to have, 400 people living there. Yeah. So that change of user is important, and it is one of the first approvals that say Savo would obtain before they even start construction. It's a change of user approval, allowing construction and of a multi-residential building. So that approval is obtained from the county government. Yeah. So when you say change of user, there's a first stage. There's a county government stage whereby the approval has to be sought.
Yeah.
So that stage, once it's been obtained, you get what's called a form PPA2. So whenever, we talked about due diligence and the documents you receive, one of the documents you should look for is a PPA2 to see that the change of user has been applied for and approved. So that is the change of user, which is important for projects like this. Change of title.
Yeah. So change of title is essentially it's like the final step of that particular process. So the moment you get the form PPA2 from the county, that's not the final step. So the developer is now required to go to the National Lands Commission. And when they go to the National Lands Commission, they're telling the commission that we got the approval from the county, and now we are come to this body to give us the approval to change the use of the property and have it endorsed on our title. So it's usually it's a rigorous process because it has to go through several departmental approvals. But at the end, what happens is now the developer is now told to surrender the title they have, which is now has a user of residential. And once they surrender that, they're given a new title with a multi-residential use, which now shows that they've been allowed to now construct, this development. They were allowed by the county, but it's gone further and they've given them a title that actually has a user that allows them to have this kind of development on that particular property.
So what are the risks if I as Savo get some piece of land and they don't do change of user and my title is also not changed and I just begin building? What are the risks for me as an investor?
I think the first and most crucial is you're not using the property for the use it was intended for, which means that the government can actually revoke your title, or they can come to the property and actually tell you to stop constructing because you don't have the requisite approvals and you've not taken the requisite steps to get those approvals. So essentially that development is what we call illegal.
Okay. All right, that's interesting. I think there's a part in our sale agreement that talks about next of kin, where we ask for contacts of next of kins from our investors. And then there's also a term called alternative contact, an alternate contact. What is the difference between these two? And if our next of kin in an agreement, does that automatically mean that if something happens to the official owner of the contract, then ownership automatically passes down to me as the next of kin?
You can take.
Alternative, I think I'll discuss alternative contact and Fidel can expound more on the next of kin. So essentially alternative contact is basically, it doesn't really have to be your family or your relative, but this is the contact that you give to Savo, just in case that, in the event that Savo can't reach you, or us as the lawyers, we can't reach you for one reason or another, we can talk to this person and they can shed a bit more light on what's happening, or why we can't reach you. They can provide, they can provide us with a way we can get in touch with you. But as benefit in the and title in the apartment does not pass to them by virtue of them being the alternative contact. It's just for purposes of communication, because we've seen instances where you have an apartment owner, you are able to communicate with them for a certain period, and then they passed on, and you as the developer, you're now gotten to the point where you can't get them on call, you're not getting them on email, and maybe you want to know where where you're supposed to send this rent, or certain, you need to know certain decisions about the apartment. So in such an instance, we'd contact the alternative contact, who would now be in a position to tell us that this person passed on, but these are the beneficiaries to this particular,
Okay.
Yeah.
Interesting.
So I think with next of kin, this was something initially when we put it, it was more because a lot of our investors are individuals.
Yeah.
And, the next of kin is usually the next most closest person to them. So it was easy for them to just provide this information. One thing about the next of kin in our agreements, and it's also linked to the alternative contact, the next of kin does not have any contractual obligations to Savo. When we put their details there, so you may put in, your brother. That doesn't mean we're creating a contract between Savo and your brother. Your contract will always remain between you and Savo. So the next of kin, as Diana said, is just there for communication. One of the challenges we've had with this provision, which I think we have cleaned up by calling it alternative contact, is that investors would think that when they put their next of kin, they're basically saying, if I'm not there, this is the person you will be dealing with in terms of payments and stuff like that. But that's not the case. Some investors are even giving details of children, which is not agreeable, because of course children, we don't want to start calling children because you're not paying, and of course they don't have the capacity to understand what's happening. So next of kin, alternative contact, similar, but it's just the way the word is phrased. And for investors, they just have to understand it's just somebody they trust, who they don't mind us calling in case they're not reachable, or in case something unfortunate happens to them.
So you talked about in case something unfortunate happens to them. What happens? So I was mentioned as next of kin in a certain contract. Something has happened to this person, they're no longer here with us. And maybe I even completed payment. Like there are no financial obligations or anything. And even the project is complete. It's at that stage where Diana is talking about now someone needs to be receiving rent for this apartment, or they need to start living in the apartment or something. What happens? What do I need to do if I was mentioned as next of kin in that contract, or I as an investor? Then what mechanisms can I put in place for me in case that happens?
That's a very good question. In such scenarios, what happens is you as the next of kin, or you as a person listed there, of course, for just notifying the developer in Savo, you can tell Savo that this person passed on, and we are going to take the requisite steps, which is now go to court. So we can get what we call like letters of administration, which would essentially allow us to deal with the property. So you can notify Savo, and Savo will just basically update their records, and you now, at that juncture, you go to court and you apply for letters of administration. And essentially this is you asking the court for permission to deal with this person's estate or property, given that they are no longer around. Once you've gone through this process, it's what we call the succession process. At the tail end, you'll be given those what we call like a confirmation of grant. When you have that confirmation of grant, you can now come back to Savo, and now the next step will now be to transfer the title from the deceased person to you as the next of kin. So with that confirmation of grant, we are able now to transfer that property to you, and that now passes on that legal title to you as the next of kin. And at that juncture, any rent that was being collected on that apartment can now be transferred to you. Yeah.
I think a question that you've probably answered, and thanks to everyone who's joined us. Tony Kinuthe is asking, for the next of kin, can it be disputed in a will?
You see, maybe I'll just add, I think this also goes to planning ahead. And I think we've had webinars on planning ahead. So if you as an investor want to add a next of kin, and of course we're talking about adults, so you may want to add your brother, and you may want your brother to benefit. Yeah? So once you have added your brother, go and speak to a lawyer to organize a will for you. Whereby you say in your will that your brother shall be entitled to this unit. You see, now you're putting in place a structure so that even if you pass on, your brother already knows, look, I was entitled to this, I can go to court, get an order, and be able to now get the benefit of it. So it's as an investor, you shouldn't just, as much as you may want to just put anybody there, it's also planning. You know, if you want to put a close family member, think, okay, I've put my close family member, can I put in place a structure so that they do actually benefit? And also, I don't know if investors do tell their next of kin that they put them in their agreements. You must tell your next of kin because you're getting the information and putting them in an agreement. So just tell them and find ways to keep updating them on what's happening.
I think Rachel Nyigi is saying, I think it's in order to have children as next of kin depending on their age. What are your thoughts?
I think the operative word is depending on their age. Because you'll find this is a contract in respect to an apartment, and there are certain decisions can only be made by adults. So if the next of kin is a child, then it becomes very difficult for number one, Savo, to reach out to a child because they shouldn't be communicating with the child in respect to this particular transaction. So it usually helps when it's an adult, so that in case of any decisions that need to be made, then they're being made by an adult, not a child.
Okay, interesting. I think we can move to the next bit. I think in the agreements we also see a clause on force majeure. I think we've put it hand in hand with changes in law. Maybe just like an explanation of what these are, what they mean, and then maybe I can pose my questions to that.
Okay. So force majeure is it's basically what we call these are events beyond the control of either party in the contract. So a good example of a force majeure was a pandemic. We had coronavirus. So at that point, you'd find that it's not something that the developer could have foreseen. Neither had the investors foreseen that we'd have a pandemic in the year 2020 that would affect our operations to such a great extent. And what happens is they usually put a strain on this particular contract. So you'll find that I, as the developer, may want to construct the development, but because the government has given directives on social distancing, or maybe they've said all construction sites need to be closed until we've managed the pandemic, then it means maybe Savo cannot build at the pace that they wanted to build, and that actually affects the completion of the development. On the flip side, we can say quite a number of people lost their jobs during the pandemic or were on pay cuts. So you might find I, as an investor, this is not something that I had anticipated. Neither is it something that I could have foreseen, and it's not something that I'm able to mitigate. So at this juncture, you'll find I'll need to come and talk to Savo and tell them this pandemic has affected my obligation to remit payments under this agreement. How can we resolve this?
Interesting.
Maybe I'll talk about changes in law. But with force majeure as well, it's one of the most negotiated parts of our agreements. Lawyers, any lawyers who are watching, you do give us a hard time, but anyway. But with changes in law, I think this has become more prominent recently because of what's happening in the lands registry. Before, we used to have a very stable system whereby you get titles. The system was very stable and known for a very, very long period of time. But recently we've had changes in the land registry that is now changing how the titles are issued, and these changes in law can affect how an agreement is structured.
Yeah.
So, for example, I'll give a perfect example is Sunset. Sunset, which is just finishing now.
Yeah.
At the point Sunset was starting, the whole sectional titles had not yet come into play.
Yeah.
So all our agreements were prepared in line with subleases, you know.
Yeah.
So for us, you know, we were thinking subleases, but of course we had it in our mind that sectional titles were coming.
Yeah.
So we put in our agreements this change in law, because a change in law can cause delays, similar to a force majeure, and it has caused delays in how titles are issued.
Yeah.
So it's important that you know, investors understand that sometimes there are events that happen, whether it's force majeure or changes in law or circumstances, that we really have no control over.
Yeah.
We don't have control over the land registry. We don't have control over coronavirus. You know, these are issues that can cause delays, and they have to be catered for so that the developer Savo is not put in a situation whereby they're suddenly breaching every single contract for reasons that are not their own.
Yeah, and I think this is like the best part for us to apply. One of the core values for Savo is partnership, where we say we will share the spoils of war together, and if it's not a win-win engagement, then there's no deal.
Absolutely.
So for us here, it's then what happens if these things happen. It's prudent that we are honest with each other. There's a lot of integrity in terms of conveying this information and making sure both parties are at par in terms of what's happening. Because I hear even changes in law can render a contract unenforceable or can add additional expectations to either parties of the agreement, which maybe was not there when you were signing off. Therefore, it causes you to want to come back to the table and ask, hey, so this has come up, what happens? You know? And either way, like in either direction. So
just to add on that, we'll just say with the Sectional Properties Act, under the sublease system, you'd find that the developer wasn't required to, go the extra mile of surveying the entire development. So you'll find that mid-project, they're now being required to go find a surveyor who will now come and survey each and every apartment. So you can imagine it's a bit of an onerous obligation on the developer, especially if this is not something that they had factored in, but it's a change in law and they have to
they have to do that. Yes. That's interesting. I think, let me just read the comments.
Maybe also just to add, and I think this goes to that the geo-referencing, the surveying, it causes increases in costs.
Yes.
So one of the difficult discussions sometimes we have with investors is, why suddenly have your costs increased? And it's not really an intentional thing. It is just that we are trying to balance. The cost the developer is also bearing, and everyone is also sharing in it.
Interesting. I think Sahib is saying beautiful, rich conversations. Thank you. Lisa Okoth has just left a comment to ask, what happens if I die before completing my payment, but I have signed the sale agreement? What protects my beneficiary, especially if they are below 18?
Oh, interesting. I think that also goes to the next of kin issue. So whenever you sign a sale agreement, and it's something we talked about last year, planning ahead, always plan ahead. Have a plan in place. So if you don't make it through the transaction, who is going to be your beneficiary, and how is that beneficiary going to be able to access the benefit? So again, do wills, plan, structure your affairs properly, because it can be tricky when there's nobody who is legally able to take it up, because then we're all stuck with a situation whereby how do we also handle this transaction as Savo? So it's just planning ahead.
Okay. Maybe also to just shed a bit of light on that. In that particular situation, you'll find the person who becomes the guardian of that child can decide to continue making payments, and that this apartment will now be held in trust for the child until they turn 18. So if once they finish making the payments for that particular apartment, the property will now be held in trust for the child until they turn 18, at which point now it can be transferred to them to hold in their name.
Interesting. So Ahib is asking, what if an investor said it verbally and there were witnesses? Does it count?
Said what? verbally.
I don't know. I don't know if he's asking about the next of kin issue.
Oh.
Yeah.
Or signed. Okay.
Maybe I just said if today I die, this person is the one who's to benefit from
the
everything that
oral
it
like
is.
wills.
Yeah.
Yeah. Those ones you can do oral wills, but they have to be proven.
Yeah.
You have to when somebody is going now to claim and say that he was benefiting, they have to prove that it was. And there's a lot of there's a whole lot of like legal requirements for that.
Yeah.
So it's not straightforward.
It's not straightforward.
So it's better to put it in writing.
Yeah.
And you know, also for it to be valid, you have to die within 3 months of making that declaration. So if you don't pass on within 3 months, then it's invalid.
Okay. Okay. Interesting. I think what we are learning is just plan the right way in a way that doesn't leave a stressful situation, and maybe we can do another session just on this to teach on what like the future could hold. Okay, so I think we can move to the next bit of our discussion, which is execution and witnessing. And I think on that my question would be, can anyone be a witness, or does it, or are there people who are specifically designated to be witnesses?
A witness essentially is somebody who is authorized to witness parties to a contract, signing that particular contract. So in this particular scenario, it has to be an advocate or let's say a magistrate, or if you're situated overseas or in the diaspora, then a notary public. So a notary public essentially is the equivalent of an advocate who's authorized to sign documents that are being used in another country. So not anyone can be a witness. You can't give your friend the agreement to witness on your behalf, because as a witness, then there are certain things that put on them to make sure that this parties, number one, understood this agreement that they were signing, that they, that they were not under any sort of duress or nobody was forcing them to sign, and they did it voluntarily. So you see issues of explaining a legal contract and just trying to ascertain the state of mind in which this person was when they entered this agreement. Those are things that can only be done by a professional, not just your friend or any other party that you may know. It has to be somebody who's authorized to witness your signature.
Okay.
Okay,
maybe Fidel, you can tell us about what execution is.
So execution essentially is when you sign. So investors, of course, they'll sign the agreement. Some of them sign and then send it back to us without having it properly witnessed. The agreement there is not properly signed. It's not properly executed. So it's important when they're executing, they are before an advocate or notary or magistrate, as Dan has said, to ensure that the execution is proper. It's also good for Savo as well, because they know that the person who signed is
actually
the person who signed, because sometimes you may find a situation whereby you'll send an agreement to an investor to review. They look at it, they say it's fine, and they sign and scan it back or send it back to us. But we don't know, we've never met them. So that whole witnessing. And also with the advocate and notary, the good thing is these are authorized persons, so they have obligations under the law in how they're supposed to witness. So it's important that when we see that it's been witnessed by a notary, we know this person has properly executed the document.
Maybe what I'd ask is so there's execution, which is the signing, and I think you've alluded to if a document is not well witnessed during the execution, then it's ish. If a document is completely not witnessed, does it render the agreement unenforceable?
To some extent, the document, it can be set aside because there's no one to confirm that this document was signed properly and that the person who signed it understood what they were signing and they did so voluntarily. So it just puts you in a risky situation where you have an agreement for sale, but it can be set aside. You have a contract that can be easily set aside. So our preference is we do everything to the T. We cross our T's and we dot our I's, so that we have the agreement for sale we have cannot be set aside on just formalities. So it's just following the basic formalities.
Okay, that's interesting. So even if you have a draft agreement in your email with your unit number and your name and your wherever, that's still not an agreement, because you have to have it signed, you have to have it witnessed for you to actually stand in the event that, you know, for your own protection.
Yeah, and maybe just to go back to like where we started when we were talking about the offer letter and the sale agreement. Another difference is you'll find the offer letter is something that you can just sign. The developer and the investor can just sign the offer letter, but you know, the agreement for sale, because of the serious nature involved, you know, and it's conveying property from one party to the other, it needs to be witnessed by people who are actually authorized. So you'll find with the offer letter things are a bit more lax, but with the sale agreement, there are certain formalities that must be met.
Okay. Okay.
I think also a challenge for investors in witnessing is they feel it's costly. But I think for investors, you need to look at it differently. Signing and having it witnessed properly protects you, as an investor. Not signing it or not avoiding the witnessing puts you in an exposed situation. So there's no need for not spending that extra to have it properly signed.
And we want to eliminate all risks possible when we are investing. Especially the things that are within your control. You don't want to mess with that. I think we can move on to the next thing, which is actually very interesting. So we've finished 24 months of our project. We've constructed, the units are now ready, and investors are asking, hey, so now I want ownership. I want to get a tenant for my house. You know, and the most asked question is, what's the difference between possession and ownership? And then now that brings us to like whatever we were to discuss, which is practical completion and sale completion, and what are the differences between the two, which puts you in a better place to call yourself like an actual investor of unit this and this and this, you know?
Okay, maybe I'll start. So, and the perfect example is our friend's Sunset that's just finished. Some investors have already received their what's called a practical completion certificate. So when a project is completed and is ready to accept people to move in and occupy and hand over and all that, what happens is a practical completion certificate has to be issued. And the practical completion certificate is basically saying the building is complete and all works that were required to finish the building have now been done. So that then allows the next phase of what you now call the residents coming in, the tenancy starting. So it's an important stage because it's obviously for an investor it's a key stage because it shows you're finished and they're happy. The project, whatever they were paying, has brought up what is now live. But it also allows them to take over possession, provided they finished paying their purchase price. So practical completion is very important milestone.
Okay.
And within practical completion, there's also a period called a defects liability period, which I think investors who have looked at our sale agreements will have seen that period. So the period 6 months after the practical completion date, whereby for those investors who have finished paying, they can now go to the unit, have a look, see that it's any defects that they see, they can then inform the developer and ask them to rectify. And those repairs are done at the developer's cost. So there's that period, a 6 months period called a defects liability period.
That's interesting. Sales completion.
So the sale completion date, this is the date on which the purchaser number one has finished paying the full purchase price. The developer has completed the development. They have done the geo-referencing. They have finished the change of user, and we've gotten the new title. So at this stage, both parties have complied with the obligations under the agreement for sale, and it's now, this is the date where we're saying we're ready to move on to the final stage, which is now transfer of the sectional title from the developer to the investor. So the sale completion date is the date on which shows each party has met their obligations, and we can now start the process of transferring the property from the developer to the investor.
Okay, I think what we've done in Savo is once a building is complete now, like what you're talking about, Sunset, just a few meters from here, when a building is complete, we actually put in residents in the house and people start earning rent. And by the time I have finished completion of the purchase price, so if my unit was 1.8, I have paid the 1.8, you can start earning rent based on the way we run the business. Because we have done this, most people feel like, I'm earning rent. What's the importance of going the extra mile to actually complete this sale? So you'd find people are not paying stamp duty to actually be recognized as owners, as owners of the apartment. You know, like people take this thing lightly. As long as they started earning their returns, it becomes like a light conversation of, I'll just do it. I'll just do it at whatever time. But I think what we are alluding to is there's practical completion, which allows for the occupation of people in the unit, but there's also self-completion, where now you become like the actual owner of that particular apartment. I think that then brings us to the beneficial owner and registered owner, which could be explained in those scenarios.
Maybe just to give a bit more detail. You'll find in some instances beneficial ownership essentially just provides that I derive benefit from this particular apartment, but I can have beneficial ownership and not legal title. And one scenario where this can arise is I paid for the apartment, I've not taken the requisite steps to transfer the apartment from the developer to myself. So you'll find legal title in the apartment still lies with the developer. But I am enjoying the benefit from this particular apartment. Another scenario might be in the instance where we're talking about where somebody had passed on and maybe the beneficiaries who had been left there. So in that instance, you'll find that they're the beneficial owners and maybe the people who are managing the property for them are the ones who have legal title in that apartment. But just to bring it back, in this particular scenario, it's important for you to have both legal ownership and beneficial ownership in your apartment because it allows you to transact with the apartment. So should you want to, sell the property, it's easy for you to sell the property to a third party. If you want to use the property as a security, to maybe get more capital for something else, you can use the property for that. But if you don't have legal title, then it becomes very difficult for you to deal with that particular property. So it's important for you to make sure that both those types of interests are vested in you as the owner of the apartment.
I think even before we go to registered ownership and then like dive deeper into the project, we can talk about beneficial ownership and the benefits you get from investing in real estate, which is now your rental income. And here at Savo, we try and make it very passive. Then that will bring us to property management and resident management, which very many people, up and including some of us within the organization, really confused what's the difference between these two. Because by the time I'm getting a unit D101, I'm calling this a property. So if someone is coming to do management, me, I'm thinking, you're managing D101. So what's this charge for? Stuff like that. So maybe we could just say what are the key responsibilities when we're talking about property management, and what are the key responsibilities in resident management.
Maybe I'll talk about property and you can talk about resident management. So property management has two facets within Savo. One is the wider common areas. So there's management of that. So Savo Lifestyle will manage the wider common areas, but to do so they need investors to pay the service charge. So I think this is always a bit of a fight. Maybe you may want to expand, I don't know. But so the obligation of an investor once they get ownership, beneficial ownership, is that they also have to start remitting the service charge. This can happen in two ways. One, if they're owning the unit and managing it themselves, then they have to be responsible for that. If Savo Lifestyle is managing it for them, or what you call property management, in respect to that unit, Savo Lifestyle will collect it from their resident, and then they will remit it for purposes of the common areas. So the common area management is very critical because if it's not managed well, it becomes inhabitable. the place becomes dirty. It's completely, it becomes a place where people don't want to live. So getting even tenants to come into a place which is not well managed, it becomes a problem. So as an investor, it's very critical that investors meet those obligations as soon as they're able to receive rent. Then there's the other aspect of property management Lifestyle does, is managing the actual units. So they make sure their unit is well catered for, well maintained, and the tenant is brought in. So maybe Diana, you can talk about the residents and the tenancies.
Yeah, so resident management, essentially I'll pick up from where Fidel left off with Sabo Lifestyle. So you'll find Sabo Lifestyle now manages that relationship between the tenant and they are the in-between between the investor and the tenant. They stand in between and they manage that relationship. So they make sure that the living conditions are great for the tenant, and they make sure that the tenant pays on time, and they actually get this money to the investors in good time. So basically that management of that relationship is what we are calling the resident management. So at this point, you'll find maybe Sabo Lifestyle has the obligation of making sure that the tenancy agreements are signed, the tenant remits rent in good time, that the conditions within the development through managing the property are ideal for the tenant, such issues. And
I think what gets most of our investors confused is because everyone would just say it's just Sabo. You're managing my unit and you're still managing common areas. But the common area management really is for the investor, whereas also the unit management is for each specific investor. I think for us the biggest thing we sell as we sell real estate is passive income. That's the one thing we want all our investors to achieve. At the end of the day, that's like the end goal for us. If you're not able to get that, then I have failed in my promise, from the beginning. So what we try to do is what you're talking about in resident management, the retention of the residents. We're also actually advertising to get those residents into the building. And if I'm getting people into this building that does not look nice, even me, I'll have a difficult time. Have a difficult time, a lot of expenses in doing advertising, whereas I actually don't have residents in the building, which affects the passiveness of the income and the meaningfulness of the investment, because this is only an investment if you're receiving passive cash flow. So those are very important things for you as an investor to note, that we're not taking money out of your pocket, but actually ensuring that you have it for the future generations, the things you're talking about, your next of kins and your beneficiaries, that this apartment you've paid for now is not just for the next 5 years or 10 years. This thing will feed your children and children's children. So for us, that's the dream, hence why we do things the way we do. I think we can move on to registered ownership and now dive deeper into now what happens. So Sunset investors have finished payment. Of course, Lifestyle will come in, we'll get them residents, will start earning rental income. What used to be and what is there now? You've alluded to that there's been a change in law that has affected Sunset. So what does that look like now that Sunset is complete? And what can the investors expect?
Okay, and I think this goes to we had initially described practical completion and sale completion. So sale completion, of course, and the thing with practical completion is on a fixed date for everybody. But sale completion is diverse for everybody. Depends on when you finish paying. So you could finish paying today. I could finish paying 3 years from now. And maybe an interesting point is not everyone likes receiving that email for sale completion. Some like it because they know they're getting the title, so they're very proactive. Others, they don't like it, they ignore it. But anyway, so that part of sale completion leads to ownership of your unit, the registered ownership. So as soon as sale completion is achieved, your title can now be registered, and once it's registered, you're then able to deal with the title. Currently, we have two systems in place for apartments. One is a sublease system, which is kind of slowly falling away, and then we have what's called the sectional title system. I'll just deal with the sublease system briefly. So like a development like Coral. Coral, when we started registering titles, we were not yet in the sectional titles regime yet. It had not yet, the law had not yet come into force. So we started with the subleases. So any project like Coral, whereby you've already started with subleases, you have to finish with subleases. And a sublease essentially is like a long document that sets out certain rules and obligations of how you as an investor are supposed to abide by certain obligations. It also has a term of that sublease, which is usually 99 years. So it's like it's a title deed, but it's just a long form of a title deed. It's like a lease.
A more wordy format.
More wordy format, which but it's been there for so long. I remember what I talked about. We had a very stable system for so long. This sublease system was a stable one. So it's slowly dying away, which I think is a good thing, because sometimes you get so many different types of documents, subleases being issued by lawyers, that sometimes it can create a bit of confusion for an investor. But still, we're still issuing them at the moment for Coral. But for new developments, we're now moving to the sectional title systems, which Diana,
will it be phased out with time?
Yeah, that's the intention. So the intention is even those guys who have got their subleases at Coral, eventually, once we have a system in place, they'll surrender those titles and be issued with an actual title deed document that I think Savo Studios is now issuing, right?
Yeah. So with the sectional title, this is the new system that came to ensure harmony of the type of apartment titles that were being issued. So like Fidel had said, I think the biggest issue with subleases was the consistency. So if you bought an apartment from Savo, you'll find they have a certain format for their subleases. But if you go to another developer, it's an entirely different format. So there was that lack of consistency in the types of titles that were being issued. And the reason why sectional titles came in is to make sure that should you go anywhere in Kenya, if you want an apartment title, it will be in this particular format. It's very clear. So with a sectional title, what happens is the first step is what we mentioned or what we alluded to much earlier. The development has been complete. The developer has issued the practical completion certificate. So at this point, the developer will also engage a surveyor, a registered surveyor, to come to the site and do what we call georeferencing, which is essentially, taking a plan of the entire development and the apartments in the development. So once they generate these plans and they take those plans, they'll go and have them registered at the county. So in this case, like if it's Savo Sunset, they'll have it registered at Kiambu County, and then they'll also now go with it to Survey of Kenya, create a file for it there and have it approved by the Director of Survey. Once that's done, then the next step is for us to go to the lands registry and apply for registration of a sectional title. This was a sectional plan that we had, that was created by the surveyor. So once we have that plan, that's what we use to apply for registration of the sectional title. And that when we apply for registration of that sectional title, we're required now to surrender the title for the entire property. And this means now that title will be cancelled and individual titles will be issued for each apartment. So unlike Coral, where we have what we call a head title, which now has the entries for each sublease. In this particular instance, there's no head title. There'll be individual titles for all apartments in the development. But also to ensure harmony in the development, when I apply for a registration of the sectional title, the registrar will also form what we call a corporation. So this corporation is what will come in to replace what we had under the sublease system, the management company. So the corporation will now, it will now be comprised of all investors in the development, and your ownership in the corporation will be based on the size of apartment you have. So the bigger the apartment, the more ownership you have in the corporation. And basically the purpose of the corporation will be, number one, to oversee the day-to-day running of the development, collection of service charge, make sure that, like major repairs in the development are done. So common area. Basically, that's what they're doing. They're just looking over the common area, security, water, lighting. So that's their job. Yeah. So they're the ones to make sure the development runs smoothly. So once we apply for registration of the sectional title, the titles will be issued, and at the first instance, we'll have all of them issued in the name of Savo. And then as investors finish paying, we'll now transfer the titles from Savo to the investors. And the reason we do this is because you're not allowed to, unlike the sublease system where I can submit one for one investor who's finished paying, here I have to do everything together. If I'm getting a title, I'm getting a title for all 400 apartments. I can't get a title for 10 investors who finished paying.
But the transfers can be done
for individual.
One by one, yeah.
Okay. That's interesting. Is it easier?
No, not at the moment. I wouldn't say it's easier because number one, it's a new system, so it's learning. It's a lot of learning and seeing what works for lawyers, for staff at the registry, for all officials. Everyone is just trying to put in place best practice to make sure that it runs smoothly. But I think eventually we'll get the hang of it, and everyone will become more familiar with these types of documents, so things will run more smoothly. I believe over time it will get easier, but at the moment there's a lot of learning to be done.
More stable, as Fidel says. I think that's a beautiful way to end our discussion today, as we talk about sectional titles and ownership and property management and rent, which as a real estate investor, that's what you're really yearning for, or you're getting into the investment for. So for our investors at Sunset, that's a real joy for them. The whole of this month we've been now onboarding residents. We started onboarding residents on the 15th of May. So by the 1st of June, people will start living in their apartment, and some of the investors will start earning their rental income. And the team has been really on ground trying to ensure that we can now fill up all the units so that all investors can enjoy this. So I think just maybe a thank you to all investors who are here that are from Sunset. It's been a journey of 22 months with all of you. And for others it's still gonna be 60 more. We have like 36 more months to go, I guess, for you to complete your payments. We hope you will all take the registered ownership thing very seriously, so that as you finish payments, you can start working on making yourself like actual owners of your units and not just beneficial owners. In line with that, I think we have a celebration on the 27th of May, which is the next Saturday, but one. So you're invited. Please come celebrate this great milestone with us, because you've been with us throughout the journey. Fidel and Dana will be there, so you can meet them in person. We will all be there, so you can meet us in person and not just on screen. And you can get a chance to ask us. I think you'll have a station where people can ask you all the questions they would want to know about the project and the way forward, in case you have missed anything. I really would like to thank everyone who's joined us, and I hope I didn't lock anyone out. I think as I close out, after Sunset, next weekend on Friday, which is the 19th, we will be having an open mic session in one of our projects at Wanye. We're inviting you to come join us and show us what your talents are. So Dana, if you can sing, you can join me. You can join me for that. I think thank you for being here with us. Thank you, Fidel and Dana, for joining me today. Have a good night, everyone. So
good night.
Bye-bye.
Good night.
Bye.
Owning your first apartment in Nairobi has never been easier. It's simple. With 0 deposit and 0% interest rate, you can pay as little as 30,000 per month for up to 5 years. Just divide the price by the number of months you want to pay. Visit www.savo.ke to learn more.
They say that the youth are the future, but we believe that the youth are the present.
Change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek.
Join a community of the change makers, the innovators, the visionaries who dare to dream big and make it happen. They are the ones who will shape the future, who will challenge the norms, and who will create a better world for us all. Those who dare to dream big and make it happen. Click on the banner to join the movement today. When it comes to investing in real estate, there are a few key factors that can make all the difference, and our newest project, Savo Divine, has them all. First, location. Savo Divine is perfectly situated near USIU in Roysambu along Thika Road, giving residents easy access to the CBD, all the amenities and opportunities the area has to offer. Second, community. At Savo Divine, we've designed the apartment for a vibrant community of university students and young professionals alike, with communal areas, co-working spaces, and spaces to build, enhance, and promote communities. Savo Divine offers an affordable payment plan of up to 5 years, with studio apartments starting at 2.1 million Kenyan shillings, superior studios at 2.6 million Kenyan shillings, and one-bedroom units at 3.1 million Kenyan shillings. The biggest setback to investing in real estate is deposit. And the good news is, you don't need a deposit to start investing in these projects. Just divide the price by the number of months you want to pay. Investing in real estate has never been easier. If you're looking for an investment property that checks all the boxes, look no further than Savo Divine. Visit www.savo.ke to get started on your investment journey.
Leo kutawaka moto fire. Wadau. Lakini kitu ni vya pressure bana. Siwezi kuwa misi chef. Siwezi choma mahindi alafu tena misi dancer. But allow me to reintroduce myself. So welcome back, guys, and last time we talked about financial independence, and we defined it as having assets that generate sufficient passive monthly cash flows that enable you to satisfy your needs, your wants, and your desires. So I'm just trying to think of a day when I've achieved financial independence. You know, I just wake up in the morning, go for my jog, get into my Bentley and drive my kids to school, come back home, have breakfast reading the newspaper that has been delivered at my door. Guys. So what is that amount of money? What is that amount of money that I have to earn passively so that I can be able to do all of these things that I'm passionate about? Join us next time as we do the fire drill, as we get to know where exactly your money goes to. Thanks, guys.